Welcome to another edition of the Litigation Psychology Podcast brought to you by Courtroom Sciences. I am Dr. Bill Kanasky, joined with my co-host Steve Woods. Steve, what's shaking down in College Station?
Nothing. It's 80 degrees in November, so I can't complain about that. I know our other guest here is can't say the same thing. So
Actually, our guest is a very good our guest is a very good friend. We've grown very close over the last couple of years, and particularly the whole summer that we essentially spent together in New York City, specifically in Chinatown, on a massive trial that we're gonna talk about today. Our friend, the myth, the legend, Tony Battista. Tony, how are you?
I'm doing well. I'm coming to you live from Times Square. It's about 36 degrees. Unfortunately, it's not quite as warm as where Mr. Wood is, but it's good to see you both and good to be back chatting about trial techniques.
The band is back together. By the way, it's 77 and I mean, there's not a cloud in the sky here in Orlando. So, but you know what? I'm bringing the whole family up, Tony, in about a month, and we're gonna go have some Italian food, which we'll talk about later because we're gonna have dinner in New York City. So we wanted to bring Tony on because, and I'm not blowing smoke. Tony's one of the finest, if not the finest, defense, maybe just trial attorney I've ever seen. Very, very talented, and we worked on a very, very complex and very sad case for the last couple years. And Tony works in specifically in aviation law, which is an area of law that's pretty niche. And I had worked on a couple of cases throughout my career, but this was the first real big one. And Tony, I know you've told this story to Steve and I before our audience. Kind of give us the 2-minute version of your background and how you became an aviation attorney, because I don't think that was the original plan.
No, not at all. The original plan was to work in the airline industry. Funny enough, I was grew up turning wrenches at my dad's gas station just outside of JFK Airport, and had an opportunity to load planes one summer right out of high school. And I took that opportunity to go work for British Airways. And 6 weeks in, I was hooked. They shipped me overseas to do some training courses. I learned how to be a flight dispatcher, went into various educational programs back in the day, and I thought I was going to be a lifelong airline employee. Um, but then I fell in love with the law, and I found Condon and Forsyth in the late 90s, and I've been here ever since, practicing aviation law. I represent airlines. I represent different aviation entities. I do a lot of commercial work. I do a lot of crash work, and the trial that you referenced and had such kind words about, uh, Bill, that was a helicopter accident here in New York, which very tragic
Yeah,
results.
very, very, very tragic. So given this is a great question. So given your background and experience, because I know I'm a lunatic when I'm out in the real world based on my experience in this industry, particularly when I'm driving and I'm driving next to trucks because we do a lot of trucking litigation. We do a lot of product liability. So like when you have to fly commercially, are you just a nightmare on the airplane? Like you
I
see things.
absolutely, I absolutely love it. I'm as relaxed as could be. Go to sleep. I fall asleep before the flight leaves. Um, I have great faith in the industry and everything that goes into it. So I'm exactly the opposite. Whereas my wife, she's a bit white knuckled and she gets a bit nervous and
Well, yeah. Well,
doesn't
Steve
really
and I,
like it.
Steve and I always sit in the exit row, and Steve and I have like a full like critique of the safety briefing beforehand. And if they skip a step, I'm like, hey, hey, that door is 37.2 pounds. Okay, let's make sure we have real people in this exit row that belong here. Steve, that's. I mean, you and I are like just bad with that.
yeah, and we're constantly texting each other. Bill, you could get a load of this. They got some 75-year-old person sitting in the exit row. This
Can't
this
do
door's
that.
not getting open.
Oh man, you guys are a problem right from the beginning. Right
We
from
are
the
we,
beginning.
we are a problem right from the beginning. So let's talk a little bit about the lifespan of this case and more of a general question, Tony, because this I think this was the biggest and most complex case I've ever worked on in my career. How do you approach how do you approach a case in which, and everybody talks about like it's a bet the company. This was a bet the company case, right? So it's a bet the company case. There's multiple fatalities. It's very high exposure, and the cherry on top, you have multiple co-defendants that are not friendly. How do you mentally approach a case like that early on? Because that's not the typical type of case.
Unfortunately, it's kind of typical for our firm. Being an aviation boutique specialist firm, uh, we're kind of built for this. And I think step number one is you have to have a good team in place. So even though we're a boutique firm, we're about 50 lawyers, and but only thing we do is aviation. It's the only thing we focus on it. That's what we do. And to be able to handle something this complex, you have to have a team in place to really know how to tackle it from day one. And that's the important part, getting out there and getting everything organized straight away.
And let's describe this so people know the scope of what we're talking about. Describe the number of, I mean, this is the biggest legal team I've ever worked on. I mean, describe the number of attorneys and staff on this team. I mean, it was incredible.
Well, for trial, we were looking at a trial that they predicted to be 2 months. It ended up being three and a half. And we were staffed with, now to be able to do witnesses every day, you have to have 4 trial attorneys. You have to be able to rotate, and you need four really seasoned trial attorneys that can work together seamlessly. And you can alternate witnesses back and forth because things happen during trial. I mean, you say that, but Bill, you'll remember that the day before jury selection, what happens? I get the sniffles. They hand me a COVID test, and oh geez, it's COVID. And then one of my colleagues, second chair, he gets COVID too. And we were lucky because we had a 12-person team, 4 trial attorneys, and then we had sets of lawyers behind us and paralegals and you guys. So we had 14, 15 people. We had 2 paralegals, 2 assistants. We had you two. We had a hot seat person,
Yeah,
and we had almost a dozen lawyers at the peak.
that's it's hard to keep everybody on the same page. You know, communication is key, and yeah, that's a lot of moving parts. I know I learned a lot from this experience, and it was really incredible. I can assure you this during the trial. I know that you'll both agree. Like a lot of crazy shit happened. Like every week, something crazy happened. Like
Yeah,
something
Well,
insane.
that's the beauty of it, though. You,
And
you
that's
never you never know what's going to happen.
you never know what's going to happen. And I'm going to talk to you about this because the one thing that's really stuck out, uh, which maybe the team struggle with this at the time, but you have the experience and maturity to deal with. You always said, on trial, you're going to have some good days, you're going to have some great days, you're going to have some bad days, and you're going to have some horrible days. And every morning, you had a little skip in your step, and you were super positive no matter what. Can you talk to our audience, there's a lot of attorneys that listen to this, and some claims people too, about the importance of just keeping your head straight during a complex, long trial and not letting the scoreboard kind of get to you at the end of each day? Because again, there were some pretty tough days in this trial.
Absolutely. There was I guess there was over 65 days in the trial. I would say 35 were good and the rest not so good.
Yeah,
And it's hard to keep an even keel, but it swings. The pendulum swings back and forth. You're going against great lawyers. And
yeah.
and this case had had 5 sets of teams, 5 teams of great lawyers that do trials regularly and really top of their game. Directs were crisp, cross were crisper, and you had to be creative. You're talking about, like you said, bet the company litigation, terrible facts,
Oh,
terrible tragedy. And how do you deal with that? Tough witnesses, and you go, people's emotions run high and they run low, and it's trying to keep everybody in the right frame of mind to come back the next day. And You're going to laugh, but one of the most important things was breakfast and
Yeah.
getting people straight and getting people started.
Yeah, so there was so we had a system. Let's talk about the system. Was it the Trio Cafe?
Triadina.
The Trio Diner.
Shout out to Nick.
Yeah, so we got to go on a little walk every morning, which was a good walk. Sometimes stepping over human waste in certain areas of the city, which is just part of what it is. But it was a good little walk in the morning. And the revenue that the team provided to the cafe had to be exceptional over the summer. I think everybody probably got bonuses at the cafe, and it was fabulous. It was a great diner with amazing food that was just a couple steps away from the courthouse. But yeah, I do agree. It was a great way to kind of get the day started. Everybody get on the same page, and I think that that morning routine uh, was perfect. But let's kind of back up the timeline here. So talk about being a trial attorney. And this is before even Steve and I were involved. You get the call on a case like this, and you immediately have to dispatch you and a portion of your team to kind of go figure things out. You're dealing with the NTSB, pure chaos, right? How do you deal with the situation where you have pure chaos, very nervous client, obviously? You got the feds, right, running around like ants all over the building. Um, Kind of an incredible story, right?
Well, it is, and it isn't for us because look, this is what we do. So we're ready at a moment's notice to go out and respond to an accident, an aviation accident. We've been, you know, we were involved in the 9/11 litigation. We represented American Airlines. Another crash in local areas, the 587 crash, American Airlines, another American Airlines crash, the Colgan Air. So this is what we do. So on a
Yeah.
moment's notice, we get the call, we go out there, and well, first things first, we got to settle everybody down.
Yeah.
It's a true tragedy. It's very traumatic for everyone involved. Um, I've unfortunately had the experience of going through several of these, and they're all extremely difficult. And it's
Yeah.
just providing some steadiness in very uneasy times, top to bottom, because these people that you're talking with are going to be the witnesses down the road that are going to show up at trial, and it's keeping them even keeled. It's letting people know it's okay. It's letting people know that there's help there, and what to do because nobody ever knows what to do.
Yeah. Yeah. It's definitely definitely a very tough very tough scenario. And then discovery starts. So I remember I originally got involved with deposition training for for our key witnesses, and we had we had some management people, we had some former employees that that had moved on, and like you had said, the evidence here was pretty rough. It's pretty rough. This is a unique case in which the entire accident essentially was recorded on film because of the nature of this business, and that was very difficult for these witnesses to watch. And we had witnesses that cried. We had witnesses that almost yeah, had kind of PTSD symptoms from this. And can you talk a little bit, if you remember, very early on in the witness training, how um, we purposely didn't like just go showing people that video. Like we showed still shots, right? And then we had to kind of really, it was a very psychological process to really assess, kind of where these witnesses were at emotionally. And some of them were complete train wrecks. And I don't blame them for being, and others were kind of okay with it. Can you talk about handling the emotions of sitting with a witness and going over really difficult material, not just on the video, but then, obviously you have things like emails and text messages before and after this accident. They're pretty tough to go over.
Sure. Look, these aren't normal cases.
No.
You're dealing with life-altering events,
Yes.
and now you're going to ask a person to remember things that they just want to forget. You're going to ask people to talk about tragedy over and over and over again, and then you're going to do it, in a room with a dozen lawyers, cameras, and an aggressive attorney asking questions, even before you get to a courtroom. So this is a very traumatic experience on top of trauma that's already been suffered. And people don't want to do it, and it's very difficult. It happens in all these cases, and the key is really understanding and getting people the help they need early on to try and get them through the events, and then bringing in people like you folks to assist in the process, and determine who's the best, who can do it, who can't, who's not worth doing it for because it's going to be too much, and where's that fine line, and how do you defend the case? It's difficult, and it means building relationships early on with these witnesses, and helping them get through it so that they can talk about it, and desensitizing them to some of the events. Sometimes it happens, sometimes it doesn't, and you can see, doing this for a long time, you never know what the outcome is going to be, and you can't blame people for doing the best that they can. And
yeah. Now, something you did during those deaths was just critical, particularly some of the more emotional witnesses, and it was a very, very talented, but also very aggressive plaintiff attorney who really wanted to beat up these witnesses. And I remember in our plan, which I think you pulled off very successfully, you called timeouts, you called strategic breaks during these deaths, knowing when the temperature was too high. He was not very happy with that because he was going in, to try to get these witnesses as upset as possible, because obviously upset witnesses don't testify very well. Can you talk about how you really forced in breaks for these witnesses at the right times, regardless of how happy or unhappy other attorneys were in the room, to protect your clients?
so think about this. The psychology behind depositions is witnesses can only stay focused for a short duration. So you don't want to go more than 40 minutes, because a person loses focus, loses the ability to answer questions effectively, and you're trying to protect the witness, both from a factual point of view, but then from an emotional point of view, because the witnesses will start to break down. And very seasoned lawyers, they're looking to paint a picture. Plaintiffs are looking to paint a picture of a villain, somebody to blame, and somebody to blame in an outrageous manner for a tragedy. And we see it over and over again. It's the same type of formula, whether it's this case or cases prior and cases in the future. But taking breaks during depositions is one way to get people to reset.
Yeah.
Get your emotions back to where they need to be, and then also to bring the temperature in the room down a bit. So one of the techniques that we used was breaks, and others was objections, and sometimes it was too emotional and too aggressive, and that's what the lawyer's there for, to keep everything fair. And that's what we had to do.
Yeah, and we did a lot of work desensitizing the witnesses to exactly what they were going to see. So by the time they got in there, it wasn't didn't have quite the shock value, because all that stuff was used about the depositions and trials. So that was we put a lot of time and energy into preparing those witnesses, which I think was key. And then it came to the point after all the depositions were done. Steve, we did I think the longest mock trial in courtroom sciences history. Can you tell our audience the design and methodology of this thing? Because this was the biggest project we have ever done, but we needed to because there were so many witnesses. We had co-defendants. It was really incredible. Can you kind of outline what we did in that week in Manhattan?
Yeah, so what we ended up doing was essentially a 5 day mock trial. Typically we do 1 to 2 days, and even 2 days sometimes people feel this is too long, but we actually did a 5 day on this one, which was needed. We spent a lot of time, and it gave us a lot of time to go through and give longer, more extended opening statements from both our clients and the plaintiffs and the co-defendants, and then gave us time too to show a lot more of the witness clips. I mean, what did we show? Close to 45 minutes to an hour of
Yeah.
several of these key witnesses. So then jurors were able to get a really good read on both the information and then the credibility. So we got a good read on what jurors were thinking about all these witnesses going into trial. And then, extensive closing arguments, and then gave them plenty of time to deliberate to a verdict rather than trying to kind of rush things. So we were very slow, methodical, and deliberate on this to make sure that the information we had going into trial was extensive and informative as we could be.
Yeah.
Now, one of the things that in these type cases across the board is doing your research and getting it right, and testing the witnesses through the mock trials, and not just focus groups, because early in the case, these cases go on for years. So 6, 7 years is the norm. Sometimes some cases have gone on for 12, 13 years. But in year 1 and year 2, you have to have your game plan. How do you do that? You start with a focus group, right? And it's kind of a figure out what your themes are. And then as you do depositions, these are all videotaped. Then you can do your mock trials because you have video on it. And I personally, I think you guys are a tremendous asset, and the research is incredibly important to mold the trial themes and what the next steps are going to be, because you have to build off the analytics. And what you don't know, if you don't do the research, is how people will react. And silly things like, do you mention alcohol? Well, we had a trial 20 years ago where the defendant was an alcoholic and he died of a heart attack. And the issue was, do we bring the alcohol in? And we did testing back then, and everybody said you have to mention he was an alcoholic. And the testing back then said, no, don't mention it. Don't mention it. It's not going to help you. And everyone wanted to mention it, but we didn't, and we won. So it's trusting the analytics. So hard to do because sometimes it's so counterintuitive.
Yeah, and many of the cases Steve and I work on, the key question is, do you blame the plaintiff for a portion
Oh,
of the liability? And if you do, to what extent? And no one really knows. And so I think let's go back to the kind of the team approach to this, because when you have a team, it's great because you have support, you have everything covered. I think one of the challenges of the team is everybody's got their opinion.
Yep.
And a lot of differing opinions. And where I see many of legal teams struggle is their heart kind of gets in the way of their brain, and there's this emotional, this is what we got to do, but there's really no analytics to support it. And that's a battle, because I think as you're planning for trial, several people on team may have different thoughts on strategy, on and what we had to do, which was just like our story. I mean, there was 10 different ways to tell this story. And which way what do you lead with? What's in the middle? What do you bury? What's in the end? And we put a lot of work into empirically figuring out what was going to work, what was not going to work, what was going to fall short, and most importantly, I think, kind of what was going to blow up in our face. And we figured out a couple of things in our research, particularly with the plaintiff issue, that if we went after the plaintiff, it was not going to work out very well. The jury was very not happy with that strategy, despite what despite what what many people thought. And so I'm so glad that we did that research.
Well, I
Well,
have a go ahead, Tony.
here's the thing. Um, you, you can't you have can't be afraid to do the research. And then here's the next thing that people forget to do all the time is to redo and retest the
That's it.
research. And we retested it 3 times. And we've done that in other cases where, you want the creativity from your fellow teammates. You want the different trial themes and different ideas. And then test them, narrow them down, and then test them again and test them again until you really think you have it honed to the right spot, the right niche to achieve your goals. But then the hardest thing to do is follow it.
That's
And I
the
know Bill's
hardest
going to
thing to
get to
do is
that, right?
follow it. It's the following it because again, and Steve and I have written a paper about confirmation bias, right?
Yeah.
And these attorneys, they get locked in to what they want to do versus what they should do. Steve, talk a little bit about that because we struggle with this on every case.
Yeah, and that's kind of where I was going to go with Tony, and then you can kind of piggyback off of that about kind of where you started with the case theme, the development, where your thoughts were, but then where you went, like how much you changed strategies from where you started to where you ended with the research that we did. But I think going back to Bill's point too about confirmation biases, a lot of times we see you get locked in on your case, you get locked in on your theory. The jurors are telling you they don't like that theory. The jurors are telling you should go a different way, but it's really hard to get out of your own way because you're so invested in the way you worked up the case, the way you're viewing the case. So when jurors tell you that they don't like it, you do these mental gymnastics to say, well, the jurors are just stupid. They just can't understand our case versus saying, hey, you know what? Maybe we just need to listen to the jurors and then maybe we need to reevaluate the way we're looking at it.
Yeah, and I'm going to get into our juror profile here in a second, but I want to piggyback off of what Tony just said. I think the key, one of the key things we did ended up being very important. We knew after our 5-day mock trial, there was a couple areas we were in big trouble. And one of them was, okay, our key witness is not coming across very well. We're going to have a really, really, really solid direct examination or rehabilitation examination of our witness at trial. And you never get that in deposition. So the videotape that they saw at the dep was essentially all cross-examination because that's what deps are. The really human side of this particular person never had a chance to come out. And so what Tony and I decided to do was, you know what, we need to do an additional, we're just going to do a focus group. And what we did was in the morning, we played clips of the original mock trial. We played all the arguments. And then we brought this witness in live in front of this focus group. And Tony essentially practiced doing a direct examination to get what we needed out of this person, to get the human side of this person. And that was really, really important because what we figured out was that the data we got after that, even the most pro plaintiff jurors, after that, after Tony's examination of him at that focus group, even the most pro plaintiff people were like, I kind of feel sorry for this guy. This guy's been through a lot. It worked. Our data, while the data wasn't exactly where we wanted, we definitely saw improvements in our case based on that testimony. Tony, can you talk about the importance of doing that final test to really test our key witness and knowing what we had to do at trial to get the human side of this person out?
So 3 different things. Number one is you're getting data on the human reaction, right? What people think. And we were getting it across the board, 36 different individuals evaluation, and we're getting all that data. So that's great. But number two is you're seeing the witness react under pressure in a real circumstance and answering real questions. You're learning how that witness is going to perform and what the goalposts are. How far is he going to go? What are the responses going to be? And then from the lawyer's perspective, you're practicing in as accurate circumstances as possible. You're practicing what it's going to be like doing a direct at trial with this particular individual. It's your key witness. What's that like? What's it going to feel like? How are you going to do that? What's the chemistry?
Mm-hmm.
Is there chemistry? Because if there's no chemistry, you got to do something different. You got to get a different lawyer because the witness has got to be there. Maybe I'm not the right person to do this exam. But you got to learn that. And we did. And it was an invaluable experience for everyone around. And we learned a lot from it. And that's why I say you have to test and retest. And every case where we put the time and the money and the effort into doing the research, it always pays dividends.
Yeah. So let's transition to jury select because I think this is the most important part of this case. Is it's a unique case where, again, it's a bet the company type case where we knew from the research, okay, on liability questions, we're getting tagged. Like there was no way around this, and we knew this. And quite frankly, this plaintiff attorney was very big on punitive damages and wanted to put this company out of business. And so we had to create a juror profile for jury selection. And Steve, I'm going to hand this off to you because you and Tony sat there. That we had to figure out, okay, what types of like, and again, you have to keep your head focused because you're not thinking like, what types of jurors are good for us on liability? It doesn't freaking matter. We need what types of jurors aren't going to just go crazy on us on damages, which is a very, very different, a very, very, very different question. So, Steve, can you talk? Because I got to tell you, this profile, and I'm going to say this. Most defense attorneys I see getting in trouble use stereotypes when picking juries, right? And you get this, oh, I don't want minorities on my jury. They're going to kill us. Like we found a profile where like, wow, like the traditional defense profile just does not work here. In fact, it's the opposite. And to have the knowledge of that going into jury selection was key. Steve, why don't you, and you and Tony can kind of work off of each other here. Why don't you kind of lay out kind of what we found in the research, which was not necessarily expected, and kind of how this jury selection process, because they went through what 500 jurors. I mean, kind of lay this out on kind of what you two went through during this week of jury selection.
Well, it was hell. I think
Yeah.
Tony can agree that it was hell. But not going too much into the profile, but it was a different profile than what you would typically get in a defense attorney's kind of what your thoughts would be. But I think that biggest thing is what you had said is we kind of knew we were going to get tagged on liability. So you had to shift your mindset to let's look and try to avoid any sort of high damages jurors. So the questions had to focus on high damages. The questions had to focus on punitiveness.
Yeah.
What we were looking for and listening for from jurors was about the punitiveness, which I think, Tony, it became difficult during jury selection, right? It's because you and I were completely on the same page. I mean, Tony and I were sitting next to each other, passing notes, and we were just locked in, which was good. I think it helped that we were both on the same page and locked in because you get to a point where you start seeing jurors and you start hearing them say stuff and you're like, well, maybe this juror isn't that bad for us. Maybe this juror, even though the profile, they don't fit our profile, maybe they're not that bad. I mean, there was talk when you and I had to say, no, we need to stick to the profile, right? And you have to stick to the plan and move forward. Even if you hear other things, you got to stick with the game plan, right, Tony?
Well, yeah, that's that. You do the research, you come up with a game plan, and sometimes it's out of the ordinary. And these cases, there's liability.
Yeah. I mean,
It's tragedy. It's liability. What you're trying to do is avoid a nuclear verdict,
yeah.
avoid huge punitive damages, and that was the key here because New York's wrongful death law worked to our advantage on compensatory damages, but not on punitive damage. So we had a formula, we had a theory, and then we tested it, came up with this profile, which was somewhat abnormal, I'd say, for the normal profiles, and we won't go into detail on that. But while you're doing it, and it was a 2-week process, and like I said, for the first week, I had COVID, and the deep bench that we have was doing the work with Steve, and then ultimately it comes down to can you stick with the profile? Can you have the discipline to follow it? And I think for the most part, Steve, we did.
Yeah, and I think though everybody thought we were crazy though, right? Everyone thought
That's the
like,
problem.
we had to look as everyone else is saying, this doesn't make sense. This isn't how we normally do it. We need to go back to this. And you and I just had to say, no, this is what the research told us. This is what we're going to stick with in the face of maybe other people thinking differently.
Yeah, there's always debate, and debate is good, but it's the difference between healthy debate and then following the analytics. It's like picking a baseball player. It's like doing the draft. The analytics are good, but he really looks like a good ball player today. What are you going to do? It's like Aaron Rodgers, right? The New York Jets. Aaron
Here
Rodgers.
we go. Here we
The
go.
savior. He's the savior. You're wearing the Jets jersey.
I did that for you, Tony.
And then look, everything says we're gonna get to the Super Bowl this year, right? Right? Being a lifelong Jets fan, I'm so excited. I would have worn my Rodgers jersey, but look what happens. We're 3-7. We're terrible.
It's the difference between making decisions with your heart versus making decisions with your brain.
Steve and I will continue our discussion with trial attorney Tony Battista in the next episode of the Litigation Psychology Podcast.